Based on the first sentence of Section 1 of the 14th Amendment, a child born in the United States is a citizen, even if parents were ineligible to be naturalized themselves. Their child is nevertheless a citizen of the United States, entitled to all the rights and privileges and immunities of citizenship. President Trump issued an executive order ending birthright citizenship soon after taking office on January 20. Since then, there have been 3 instances where federal judges have ruled such an order unconstitutional. The order would stop automatic citizenship for people born in the United States if their parents were undocumented immigrants. Upon blocking the enforcement of the executive order, a federal judge in Maryland said that the Supreme Court has resoundingly rejected their president's interpretation of the citizenship clause. That may be true, but it may require a closer look at the judicial history of birthright citizenship. I did some homework and I discovered a great source I wanted to put you on to. Amy Howell is her name. She has scotusblog.com. And here's what I found. The Supreme Court has ruled only twice concerning the citizenship clause. U.S. v. Wong Kim Ark, 1898, and Plyler v. Doe, 1982. I don't recall teaching much about these 2 cases over the years, largely because I thought that the court had put the issue to bed. I was wrong. The Supreme Court will hear oral arguments on May 15th on the federal government's request to be allowed to implement Trump's executive order. In U.S. v. Wong Kim Ark, 1898, the Supreme Court ruled that the 14th Amendment guarantees U.S. citizenship to anyone born in the United States. Immigration officials had denied Wong Kim Ark re-entry into the United States because he was not a citizen, even though he was born in California, to Chinese resident aliens. It's important to know that Wong's parents were not undocumented. They had been effectively disenfranchised by the Chinese Exclusion Act, a law I mention often in my lectures. In the majority opinion, I believe it was 6-2, Justice Horace Gray wrote that the 14th Amendment affirms the ancient and fundamental rule of citizenship by birth within the territory, in the allegiance and under the protection of the country, including all children here born of resident aliens. However, in a dissenting opinion, and this is one we should pay close attention to, Chief Justice Melville Fuller claimed that Wong could not be completely subject to the jurisdiction of the United States because his parents were Chinese citizens with loyalties to China. Loyalty is one thing, folks, but I'm not sure how jurisdiction can be divided. When the Supreme Court hears the litigation over Trump's executive order, most constitutional lawyers believe it will center around the meaning of that phrase, subject to the jurisdiction of the U.S. However, in the 1982 case Plyler v. Doe, it helps clarify the court's traditional understanding of the citizenship clause. In a 5-4 decision, the justices rejected a Texas law which barred undocumented immigrants from attending public school, ruling that it violated the Equal Protection Clause of the 14th Amendment. Texas argued that illegal immigrants were not persons within its jurisdiction, but the court disagreed, and Justice William Brennan explained. He said, "The understanding that the protection of the 14th Amendment extends to anyone, citizen or stranger, who is subject to the laws of the state and reaches into every corner of a state's territory." Justice Brennan emphasized that this included people who entered the U.S. illegally. Whether they are here illegally or not, while in a state, Justice Brennan explained, they are both subject to the full range of obligations imposed by the state's laws and entitled to the equal protection of the law that a state may choose to establish. Lawyers for President Trump and the Department of Justice have argued American-born children of undocumented immigrants are not subject to the jurisdiction of the United States because they owe a measure of allegiance to their parents' home country. I'm thinking that another possible argument could rest upon the very act of unlawful entry into the country. Would this, in fact, be breaking one's obligation to the state? And if so, would it be the basis for the person losing entitlement to equal protection? Just throwing that out there. Justice Brennan's words seem worth repeating. The protection of the 14th Amendment extends to anyone, citizen or stranger, who is subject to the laws of a state and reaches into every corner of a state's territory. Well, I hope this helps, and I hope you enjoyed the wildlife I have here in the backyard. Fair winds.